My name is Chris Stanley. I'm the founding principal of Beach Street Legal, and this is just one slide. And today we're talking about a recent SEC risk alert on investment advisor compliance programs. And more specifically, the recent SEC risk alert focused on fundamental failures of advisors to adhere to the compliance rule, which refers to Rule 20647 under the Investment Advisors Act of 1940. This is a relatively short and straightforward rule and only has three components. The first of which requires advisors to maintain reasonably designed policies and procedures, to have an annual compliance program review, and to appoint a chief compliance officer to administer the compliance program. However, notwithstanding these fundamental tenets of the rule, the Division of Exams did uncover some thematic problems over the course of its examination of investment advisors. One such problem has to do with the failure to conduct adequate annual compliance program reviews. Either they were not conducted at all, they were not evidenced by some sort of writing, or frankly, they were just insufficient to address the specific parts of the advisor's compliance program. And just by way of background, the SEC really expects annual compliance program reviews to cover a couple topics. Matters that arose over the course of the prior year from a compliance perspective. These could be deficiencies or opportunities to improve, perhaps. Changes to the advisor's business over the last year that may warrant changes to its policies and procedures or otherwise might present additional risks. And also changes to the Advisors Act or other applicable regulations to the advisor that, again, may warrant changes to procedures or the way that the advisor approaches its compliance infrastructure. So those are the fundamental tenets of what an annual compliance program review should contain. And the Division of Exams found that advisors were not really adhering to those expectations. In addition, the Division of Exams outlined other various compliance failures that focused on a couple different topics, one of which was inadequate compliance resources, either a compliance department that was underfunded or had unrealistic expectations imposed upon it, insufficient CCO authority, meaning that the CCO really only had a title but didn't have any ability to carry out his or her job. And just as a sidebar, if you want to get an understanding of the type of expectations the SEC has with respect to a CCO, there was a recent speech by Pete Driscoll, the director of the Division of Exams, about the empowerment and authority and seniority that is expected of a CCO. That's available on the Division of Exams website under the speeches category. And finally, the Division of Exams found that there were just fundamental policies and procedures failures by advisors. Either they did not exist, they were templated and off the shelf, they were not tailored specifically to the investment advisor, they were not updated based on different risks that presented themselves, or was just materially inadequate to cover the various topics that the SEC expects to be covered. For a more full description of exactly the problems that the SEC summarized and some helpful tips on how you might approach your compliance program, your annual review, and other handling of various compliance tactics, feel free to check out the risk alert itself, which again is published at sec.gov/exams. Thanks for watching and listening.